All right, let's be real. You're a law student, probably up late, staring at this mountain of rules for your criminal procedure exam. It can feel like a maze, right? Well, in this explainer, we're going to hand you a clear, simple roadmap to navigate the entire journey of a criminal case right here in the Philippines. We'll break down how the system, which is rooted in our Bill of Rights, is designed to protect everyone involved, every single step of the way.
So here's our game plan. We're going to break this whole thing down into 5 key stages. We'll kick things off with the adversarial system. That's the foundation for everything. Then we'll see how a case even gets started, how it's investigated, and, of course, how it makes its way to trial. And to wrap it all up, we'll look at what happens after the judge makes a decision. By the end of this, you'll have a really solid grip on the entire flow.
Okay, let's start with the absolute basics. Before we can even trace the path of a case, you have to understand the field it's played on. And here in the Philippines, that field is the adversarial system. The best way to think about it is like a boxing match. You've got 2 fighters in the ring. That's the prosecution and the defense. And then you have the judge, who's the referee. Now, the ref's job isn't to start throwing punches or helping one side. No way. Their job is to stand back, watch the fight, make sure the rules are followed, and at the very end, declare a winner based only on the evidence and arguments they saw. So, how does this whole process even begin? What's the initial spark that gets the giant wheels of justice turning? Well, every single criminal case starts with a formal accusation. Pay close attention here because this is the distinction that trips up a lot of people. A complaint is kind of like the initial alarm bell. It's the sworn statement from a victim or the police that says, hey, a crime might have happened here. But in information, well, that's the official, formal charge filed by a prosecutor that actually puts someone on trial. The prosecutor only files that after doing their homework, which is a crucial filter to stop baseless accusations from ever reaching a courtroom. You know, the plea is a massive turning point in any case. Think of it as a line in the sand. Before the accused officially pleads guilty or not guilty, the prosecution has some leeway to change the charges. But the second that plea's entered, the game completely changes. The rules become way stricter. And for a really good reason, it prevents the prosecution from ambushing the defense with new accusations halfway through the process. It keeps the fight fair. Okay, so a complaint is filed. Does that mean we head straight to a big courtroom drama? Not so fast. Before a case can go to trial, it has to survive a really critical checkpoint, a kind of gauntlet, known as the preliminary investigation. Now, you're going to see this phrase, probable cause, everywhere. So what does it actually mean? In simple terms, the prosecutor is just asking, is there enough smoke here to believe there's a fire? It's not about proving guilt beyond a reasonable doubt. Not yet. It's just about making sure a case is strong enough to even justify going to trial. And it helps weed out weak or baseless cases from clogging up the courts. So, you might be thinking, why even bother with this step? What's the point? Why not just file a case and go straight to trial? Well, it's pretty brilliant, actually. The preliminary investigation acts like a gatekeeper to the courtroom. On one hand, it protects regular people from having to go through the stress and expense of a public trial that has no real basis. And on the other hand, it protects the state, our courts, our prosecutors, from wasting time and money on cases that are just going nowhere. It's a shield for both the individual and the system. And here's the thing, this isn't required for every single case. The law draws a very clear line. For less serious offenses, you might go directly to court. But for any crime where the potential penalty hits that threshold, 4 years, 2 months, and 1 day, this investigation becomes a mandatory right for the accused. It just makes sense, right? The higher the stakes, the more careful the process needs to be. And there you have it. This is the core roadmap. If you're studying for an exam, this sequence is what you need to burn into your memory. It shows that logical step-by-step journey from a simple complaint all the way to the final verdict. Master this flow, and you've mastered the basics of the whole process. All right, now we're getting to the main event. This is the part everyone thinks about when they hear the words court case. This is the formal confrontation, the trial, and the search for a verdict. Arraignment is such a critical moment. For the very first time, the accused person stands in open court and hears the official charges read out loud to them. I mean, imagine that. It's a serious and powerful moment, but it's also a fundamental right. It guarantees that everyone knows exactly what they're being accused of before a trial can even start. Now, once that trial begins, everything, and I mean everything, hinges on this one principle. It is the absolute cornerstone of our justice system. The accused doesn't have to prove they are innocent. They don't have to say a single word. The entire job, the entire burden is on the prosecution to prove its case. If they can't, the accused goes free. Period.
And the standard for that proof? It's the highest one we have in the legal world. It's not about being pretty sure or thinking someone is probably guilty. No. The evidence has to be so overwhelming that there is no other reasonable explanation for what happened. If even a tiny bit of reasonable doubt remains, the only possible verdict is not guilty.
So the trial itself isn't a free-for-all. It follows a very structured order, almost like a carefully choreographed dance. The prosecution goes first, laying out all their evidence. Then it's the defense's turn to respond, challenge that evidence, and present their own side of the story. It's this back and forth, this clash of arguments, that eventually leads the judge to a final decision. Okay, the judge bangs the gavel and reads the verdict. But wait, is it really over? Not always. Even after a guilty verdict is handed down, the journey isn't necessarily finished. There are still a few more paths that can be taken.
After a conviction, the accused has a few different tools in their legal toolkit. A motion for new trial is for when brand new, game-changing evidence pops up, or if there was a major error in how the trial was run. A motion for reconsideration is basically asking the same judge, hey, could you please take a second look? I think you got the law or the facts wrong. And an appeal, well, that's when you take the whole fight to a higher court to review the decision. Each one is a specific tool for a specific problem.
But here's the catch, and it's a huge one. The clock is always ticking. The accused generally has just 15 days to file one of those remedies. If that 15-day window closes, that's it. The door slams shut, the judgment becomes final and executory, and the case is officially over. It's a strict deadline that brings finality to the legal process.
So there you have it, the entire journey of a criminal case, from a simple complaint to a final judgment. It's a long and winding road for sure, but every single turn is paved with rules and safeguards designed to protect the innocent and ensure that justice is ultimately served. As you keep studying, remember this isn't just about memorizing rules for an exam. It's about understanding that incredibly delicate balance between the power of the state and the fundamental rights of every individual.